May it please the court. My name is Lam. Together with my learned junior counsel, Ms. Nirans, we appear for the appellants. I will address the issue of expert evidence in 20 minutes. My learned junior will address the issue of dollar income tax for 12 minutes and reserve 8 minutes for rebuttal. Your Honor, the appellant was convicted of 14 counts of child sexual assault offences, which he might be innocent of. This is because at trial, the judge has erred in admitting the evidence of Dr. Lungs concerning the behavior of sexual assault victims. The appellant comes to the court today to seek for an exclusion of Dr. Lungs' evidence on the basis that this evidence is irrelevant. I will address the issue of inadmissibility in 3 submissions. Firstly, the evidence is irrelevant pursuant to Section 55 and 56 of the Evidence Act. Secondly, the evidence is an opinion evidence about another witness' credibility pursuant to Section 102 and 108C of the Act. And thirdly, the evidence exposes a dangerous unfair prejudice to the accused. Therefore, it must be excluded at the court discretion following Section 137 of the Act. I will now move to my first submission, where we submit that Dr. Lungs' evidence is irrelevant. Your Honor, Section 55 and 56 of the Evidence Act provided that an evidence is only admissible when it is relevant, which means it rationally affects the assessment of the existence of the fact in issue. Excuse me. At trial, Dr. Lung provided evidence about general behavior of child sexual abuse victims, explain why the child delayed in disclosing the abuse, and why the child continued to interact with the perpetrator after the abuse. That evidence is just too generic, which does not help or assist in any way to assess whether the complainant was actually sexually abused or the accused actually perpetrated the abuse. The one fact that we know for certain is that the complainant never disclosed the alleged events. 14 events were alleged and none of it was disclosed. Yet, the respondent presumed that the offenses occurred and used Dr. Lung's evidence to explain the consequential behavior of the victim. The evidence itself does not have a value in resolving the factual dispute. As such, this evidence is irrelevant. In the case of R and Scarf, Gannon and Hackett, when a doctor gave an opinion upon examining an alleged sexual assault victim and concluded that the evidence is consistent with the alleged victim's account, that opinion of the doctor was considered entirely neutral and therefore not relevant. Similarly, in our case, the evidence provided by Dr. Lung is entirely neutral and therefore it's not relevant. I will now move on to my second submission, that the opinion that Dr. Lung provided at trial is about another witness' credibility. Following Section 102 and 108C of the Evidence Act, an opinion evidence is not admissible unless it is an opinion of a person with specialized knowledge excuse me specialized knowledge based on his training, study, or experience, and that the provided opinion must wholly or substantially based on that specialized knowledge. The complainant in this case alleged 14 counts of sexual abuse offenses against the appellant, yet none of it was ever disclosed to any of his family member. A 5-year-old child, when under threats, being hurt, being violated, being insecure, the first thing a 5-year-old child will do is to run straight to his mom, his dad, his trusted one, his loved one, and ask for help. Yet, after 14 alleged events, he did not disclose any of them to any member of his family, despite that he never suffered any maltreatment from his family, entirely trusts his family. None of the offenses was disclosed. However, the respondent still used Dr. Lung's evidence to affirm that the complainant was telling the truth. But does Dr. Lung has the specialized knowledge to provide such an opinion? He never met the complainant, and not only that, he never met any victim. He's a lecturer, he's a researcher. Everything he did is based on theories. He has no clinical training, no clinical experience. He never met a victim. How can a person who never met a victim being able to give an opinion about a victim? In Emma and the Queen, a similar case, when Dr. Sullivan, a psychiatrist, gave similar opinion evidence at trial, that evidence was in fact admitted. But the difference is he was a consultant forensic psychiatrist. He was an assistant clinical director. He works at the Victorian Institute of Forensic Mental Health. It is different in our case. Dr. Lung has none of that experience. He is just lecturing. We therefore submit that Dr. Lung has no specialized knowledge to provide such an opinion at trial, and therefore this evidence should not be admitted. I will now move on to my third submission, Your Honor, that the opinion and evidence of Dr. Lung provided at trial in fact expose very dangerous unfair prejudice, and therefore must be excluded at the court's discretion. Pursuant to Section 137 of the Act, any evidence that its property value outweighed by the unfair prejudice to the accused must be excluded. In our case, the appellant was convicted of 14 counts. That is serious. But there is no witnesses. There is no other evidence except the whole attention was forced towards the complainant's credibility. And Dr. Lung's evidence is there to affirm to the jury that the complainant is telling the truth by drawing a very false reasoning that a child sexual victim elicits such behaviors. And the complainant in this case